This podcast is intended for informational purposes only and should not be considered or interpreted as legal or professional advice.
Welcome to another episode of Mika Minutes. I'm your host, Mika Domingo. What do you do when you're a conservator of the person? Once again, this episode focuses on general conservatorships, as those are the most common type of conservatorships. For information regarding conservatorships of the estate, check out our previous episode. For more information regarding the process of applying for a conservatorship, check out episode 2 of Mika Minutes, How Do You Become a Conservator? If you have become the conservator of the person, that means the conservator for your loved one who is incapable of taking care of themselves due to an illness or injury, you now have the responsibility of making decisions regarding their personal and medical care. You are responsible for making sure that they have proper food, clothing, shelter, and health care. You'll need to evaluate the conservatee's needs, including their emotional, physical, and mental needs. A conservatee must reside in the least restrictive appropriate place, which is presumed to be the conservatee's personal residence. However, in general conservatorships, conservators are granted the authority to place conservatees in a different location, such as a medical facility or an assisted living home, as needed. Conservators don't need court approval to move the conservatee to another residence in California. Before the move, conservators must mail a notice of their intention to change the conservatee's residence to everyone entitled to notice. After the move, conservators must file a form with the court describing any change of the conservatee's residence. Court approval and notice to everyone entitled to notice is required if conservators wish to move the conservatee out of state. Conservators must provide notice before moving a conservatee from their residence to a care facility and provide notice after moving the conservatee from one care facility to another. Conservators should ensure the conservatee can clean themselves with or without help, that the conservatee is eating well, that the conservatee can dress themselves or has help to do so, is given reminders if needed about cleaning their residence, is able to continue doing any hobbies that they have or visiting friends and family, and is kept away from harm. With general conservatorships, conservators and conservatees share the right to make decisions about the conservatee's medical needs. Conservators should obtain the appropriate health insurance if the conservatee does not have any. Conservators should also make regular appointments for dental, eye, and hearing care. Let's now talk about the circumstances regarding the end of a conservatorship. A conservatorship may end for various reasons, including the death of the conservatee, when a judge ends the conservatorship because the conservatee has regained their abilities to handle their own affairs, when a conservator asks the court if they can resign as conservator and the court accepts, when a judge appoints another person to be a conservator instead of the current conservator, or when the estate runs out of assets. In any event, a conservator will be required to finalize their obligations before being released from their role as conservator. Once a conservator has completed the final duties and received court approval, they will file a petition for final discharge and order. Once that's filed, the conservator will be discharged as conservator. Stay tuned for our next episode.